Thank you for staying with us. Atul Subhash, the Bengaluru-based techie who died by suicide last week, continues to spark debate. A week later, his wife and in-laws have been arrested for abetment to suicide. His estranged wife, Nikita Singhania, was arrested from Gurugram. Allegedly, she was trying to evade the law, trying to evade arrest by not using any social media. But it was one phone call that she made to a relative of hers. That's where they got the location from and was finally held. Her mother and her brother were arrested from Prayagraj. In a 24-page suicide note, remember, Atul Subhash had accused his wife and her family of filing false cases against him and blamed them for what he claimed was persistent torture. But even as the investigation progresses, now a new legal hurdle awaits the victim's family: custody of his young son who seems to be missing. Atul's father has appealed to the Prime Minister, to Uttar Pradesh Chief Minister Yogi Adityanath, to Bihar Chief Minister Nitish Kumar, among other leaders, to ensure that his grandson is returned to him, and this custody battle now seems to be playing out. There's another relative of Nikita Singhania, the wife who is in the wind, who's also approached the court seeking anticipatory relief. So while we see this suicide and the custody war play out, the question we want to ask is, did the system betray Atul Subhash and men like him? And what's the solution for this?
They were arrested near Hotel Rameshwaram in Prayagraj, Uttar Pradesh, and they brought to the Bengaluru and produced before the Honorable Judge, and they have been remanded for judicial custody. Yeah, multiple teams were sent to different places, so we were able to arrest the accused.
पोते को कहाँ रखे हुए है कि मार दी है कि जिंदा है, वो भी हम नहीं देख पा रहे हैं। हमारे प्रधानमंत्री हैं मोदी जी, हमको गुहार उनसे यही है कि मेरा पोता हमको मिले, और कोई गुहार नहीं है।
Lawyer Atul Subhash joins us on this broadcast. Vandana Shah, lawyer, would also be joining us shortly. But Atul Subhash, let me begin by asking you. Now, Ashutosh Subhash, I beg your pardon. Let me begin by asking you. It's not just about the investigation into this suicide anymore. Now there is the custody war that's playing out as well. There are several allegations that are coming to the fore that the grandson is missing. The family has raised questions about the whereabouts. How exactly are they going to be getting custody of him? Is it possible for Atul Subhash's father to get custody of his grandson? And how long a legal hurdle is that going to be?
See, at present, if the mother is arrested, so in that case, now the matter will of course go to the court. Maybe the family members from the accused side will also try to get the interim custody, or maybe Atul's parents, they would also go. Now the court has to look into the aspect. There is no any specific law to that, but the court has to basically see the welfare and well-being of the child. The child is protected where his daily necessities and his security can be taken care of in a better way. So all these aspects the court has to see and decide accordingly. Now, so far as this particular arrest is concerned, obviously, Karnataka police, they have done their best possible. They have also ensured the safe, arrest of all these accused, till the time they all reach to Bengaluru police station after the arrest. And they would be, they have to be produced within 24 hours before the concerned court, which they have been produced. And based on all the documentations, everything in place, the court has further granted the judicial custody. And I think the investigation will go on, as there is clear mentioning about, the abatement of suicide in the suicide note written by the deceased. So based on that, the court will see as to how the investigation is into progress. Accordingly, the police will examine the concerned witnesses, if any, and accordingly they will file the charge sheet in future. And based on that, I think the court will decide as to what could be the legality or the chances of their bail, because anticipatory bail, what they filed in Allahabad High Court earlier, has become infructuous after the arrest. And I think one uncle, the accused number 4 or 5, is still absconding. So, I think the police will further do the investigation and try to even take the custody of the other accused if he fails to get any sort of relief from the court. I think his anticipatory bail is pending before the Karnataka
That uncle that you
court at present.
mentioned, the anticipatory bail is pending as far as the one who is still in the wind is concerned. But he, in fact, has now gone on to the Allahabad High Court, going on to say if the suicide note is to be believed, God knows who else will be in the dock and God knows who else will be targeted.
See, he would have gone maybe for the transit bail, because if he is in that particular place where he is supposed to be arrested, if he is going for transit bail, now Allahabad High Court will see what is the merit of the case, what are the allegations, specific allegations against this particular accused, whether his name is appearing there and he has also instigated this deceased to take such a drastic step. And if these things are found, it would be difficult for him to get any relief, but that will all depend on the court and the documents being produced by the prosecution during the argument. So both the sides will argue and they will see what is the merit of the case and how it has to be decided, whether he deserves to be granted any relief during his transit from Allahabad or maybe wherever he is to Bangalore police station where he is supposed to be taken, and then he would be produced finally before the concerned magistrate court, and that court will further decide as to how his judicial custody should be increased, not to be increased, or what is to be done.
But when we speak of laws that are prejudicial to a certain gender, that may be lopsided, that's a debate that this particular case has triggered as well. As far as custody goes, do you think that's a case there as well, that the argument for the law being biased towards one particular gender would be made?
Yes, this is, I think, a very pertinent question what you have asked, because I feel that father and mother both should have equal rights so far as the children are concerned. So what happens in this legal battle, that whoever takes the child away from the matrimonial place, the other party is at stake to go and fight, the custody battle for years and years. I think the courts must understand this and they should pass an immediate visitation rights order at least, which here, we have seen it also takes, 6 months, 1 year, 2 years down the line for such certain orders. If those orders are passed, at least one of the parent who is not having the custody of the child can at least have the visitation rights, can see the child, can spend time with the child. And that is very, very important and crucial. Even after when Apex Court and many of the high courts have passed certain orders that none of the parents should be deprived of having the visitation to the children, to their own children. And this is very, very important. And what is happening, that such cases are being filed, and on pretext of such cases, in most of the cases, the father is being deprived to meet his child, and then such kind of proposal that you pay this much, then I will withdraw all the cases, then I will allow you to meet the child. So all these things are happening. I'm not saying in all the cases, but yes, majority of the cases which even the High Court and recently the Apex Court has also observed and said that there have been abuse of process of law in many of such cases. So I think it is a lesson to everyone. But this case is a peculiar one,
and there are lessons to be taken from this as well. Vandana Shah joins us on this broadcast as well. And Vandana Shah, we were discussing laws that may be lopsided, that may be prejudicial towards one particular gender. Section 498, many believe, is one of them. As far as custody is concerned, because that's where the battle now stands. So there is a child that is involved in this, whose whereabouts are currently unknown. Atul Subhash's father has now appealed to courts, appealed to political parties as well, to give him the custody of his grandson. Is that possible?
Poonam, firstly, I'd like to start by condoling Atul Subhash's death. I just think that poor boy, he just lost his life because he just was under so much of pressure and he just wasn't guided properly, even by whatever the laws and whoever was guiding him. And he just was really frustrated even by all those visits. But coming to the pertinent section of can the grandparents seek custody of the child? Yes, it has happened in the past. and the grandparents could seek custody of the child. That is not against the law. But also referring to what my learned friend has also said, that, a lot of times the custody laws are misused against from one spouse to the other spouse. I do agree about that. And in fact, a couple of years ago, I had made a suggestion to the Attorney General where I had written, how do we fast track divorce cases? Because divorce cases are very different just from property matters. And they're also very different from other cases which are there because your entire personal life comes on hold. So, the two things that I had recommended was A, right at the inception of the case, forget sending them for counseling. You just start off with two things, which are the most important things in a divorce. One is access. So it is that the father and the mother get equal access till the matter is decided. And the second was, what is the interim maintenance, or what is the monthly maintenance that will be paid both for the child. I'm only on the child at this stage. What will be paid for the child and what will be paid later for the mother. But your child's interim maintenance should be decided immediately. I'll explain about that. Essentially, your child's needs, let us assume that the child is 5 years old. The child will go to school. The child will probably have some sort of help to assist the mother in looking after the child. The child has certain needs, which are the medical needs. The child has certain extracurricular needs. Now, why can't these basically be decided right at the beginning of the case when you file for divorce? When all this is not decided, then the litigants are also tempted to misuse the law. And I sometimes feel that unless we do that, there is no relief. Let's not forget that also wives don't get interim maintenances, although the law mandates that you must get an interim maintenance for within 6 to 8 months of the filing of the case. Let me clear that it's not only the wives. I've also said it before that Section 24 of the Hindu Marriage Act mandates that it is not only the wife, it is the spouse who can file for interim maintenance. So I'm talking about the wives because that is the larger context here. And 90 to 95% of the time, it's women who file for interim maintenance. I have yet to come across, I only know of one case where the husband had filed for interim maintenance. So I won't elaborate on that right now. So I just feel that, if they would decide these two things right at the inception, and of course they can be altered or amended as the time goes by. Like we say, even the Supreme Court allows changes in your
And the Supreme Court in this particular case, and not, this case, but as far as Section 498 goes, they have come out and cautioned against the misuse of such a law while hearing another case. But are we ready, Vandana Shah, for that kind of change in the law? Have we reached a stage where there is a certain amount of gender parity where the law can be decided? Because when this law was made in a certain way, it was done so because the society was lopsided in a way. Right. So there was a level playing field that was required, which is why I asked. So then have we reached that level playing field where we can alter that law again?
I had also said, a couple of days on your esteemed channel, I'd quoted figures where I said about 13,000 dowry deaths in the country, dowry cases registered in the country. 6,500 of them actually commit suicide. So you're talking about 50% of the women who have lodged the cases for dowry who are actually really suffering in these cases. So let's not make any mistake that the gender laws are completely skewed. That's not true. But what is happening is that there is no real guidance. Like if I was in Atul Subhash's case, I would have said that, there is a method where you don't have to continue going to court over there. You could have given a power of attorney for someone else to appear on your behalf. You could have sought arbitration, that's for free. Mediation, that is again for free. These are all procedures that are available in court. You could have also sought, you could have also, I've said it time and again, you could have written to the Prime Minister's office like they're doing now. You could have written to the Prime Minister's office and complained about your various issues, like he said that he alleged that the judiciary is not giving him fair justice. He could have even taken that methodology. So I also feel that education before you file for divorce, and I don't mean Google education, I definitely mean education which comes from good lawyers. And I also tell a lot of people who come to me, I say, please do go to court. There is free legal aid. If you don't want to avail of the free legal aid, no problem. At least get a general method of what goes on when you file for divorce in any matter.
Whether the time for that altering of the law has come or not, but the time definitely is here for that discussion to begin. Well, we can hope that it leads in the right direction. And in this particular case, we do hope the well-being of a young child that's at stake, that's being held paramount as well. I'm completely out of time. I thank you both for joining us here on this edition of Plain Speak. It's a wrap from my side. Right.